removed from office without adherence to constitutional procedure.
Jojol ni magistrate wollem kitindirlal ni kiti kuntulalu wati ni wati be ike bondi la officer tole ke bondi do ko la abukana ke dalila koy kan sartata kan fereta kan adunga nin tilmu manta nyola wonon jamal le keta ite la wuce wato nyinna.
Executive branch of government been dissatisfied with judicial pronouncements been made in court, often resulted in filing bogus and frivolous charges against judges and magistrates.
Nin kitolu keta hanfo kitolu tata ye kuntu nyamemma niyo mandia officer ye me ya lonko banko kunto nkola officer le moti isa lonko ibe kuma soto balol le fewja la ke la nyoka kan nakari kumolu fo men ya lonko ibe le tilinna wo jojol wala kitindirlal la pour ñin kamala ke nambara do koto itele do ku senu menke wayri amandia nyaton ko nyiye
in order to humiliate, intimidate, persecute them for their decisions.
Andu ka kenyele kan ke malundi ke detendi ke kijota ila doku kendo kan be men tamandi kan ye kitolu kuntu nyame.
Justice Jaiteh, you said this was done frequently by the executive branch.
Justice Jaiteh ko nin ko kula de melan ko aka kelun dalil na kula melan ko aka ke anno ka bo men la karola wala executive di wala santon koldi.
Who are you referring to specifically?
Niko santon kol executive ibe jumale fama.
That is the head of state,
and
the Ministry of Justice, and other ministries. That is the president and the cabinet, the ministries.
Walem akabo president wala karola anin minister bunda kote walem cabinet menu marta banko sambanya kunyalula.
And by president, you referring to Yaya Jammeh for the 22-year period in which he was head of state.
Munda niko president wala mibe Yaya Jammeh la wato men na munu banko nyaton koti ni banko kanjang sanjum anim fula.
That is correct.
Proceed, my lord.
It is worthy to emphasize that the 1997 Constitution of the Republic of the Gambia
Ninyata purkanyum foko 1997 banko sambaran sartu buko men yadada ikafo meye 1997 constitution onying
provide for the clear separation of powers
andu wenyine itandika fengolu bonyoka nke fata men keta sembolu lanyati
guarantees the independence of the judiciary.
Men yalon ko wala nyanta kiti bunda nyi londi la afaye ke kangolondi
section 120 subsection 3
wala kata bunda keme anin sabanjango la fanna sabanjango nyinti no constitution auto
which provides that
meye nyi itandiko
in the exercise of their judicial functions
ruke la doko tamandi luwa nin tilimu doko la karola
the courts
kiti bundalu
the judges
itindirlalu
and other holders of judicial office
animo kotanglu meni ya lonko palaso bebulo kiti doku bundala
shall be subject only to this constitution
wolu lardo ko be ko kundinkela abelala constitution wala sarto lekan
and the law
and law
save as provided in the chapters of the constitution
ko ya sarto lu landi nyamin na banko la constitution wala dinkira luto
shall not
subject
to control and direction of any person.
Itetarla mo womondi na yamaro nin kango kang me ya lonko itelinyanta tamaro wo yamaro ni wo mari wolu la wo kangole kang.
Section 120 subsection 4 of the said constitution
la bunda keme bunda muang njango nyina fanana ni njango ateni constitution kilinko no
advise that the government and all departments
wenine itandi ko man sakunda doku bunda lube
agencies
anin ila denna doku bunda kotengolu
of the government
men bebe man sakunda karola
accord such assistance
be nyanta o ma koyro tamandila kadi
to the courts
iti bundala
as the courts may reasonably require to protect their independence
wakati kiti bundalu fanalu nyimu nyanto le pour ila taram fambulo yo kanta aesa
dignity
ila bunya
and effectiveness.
Ila duko la saha.
Section 141
bunda keme bunda tanani nin kilinjango
paragraph 4 to 9
wala sapaka damu tanani njango kata hanfo konon to njango kang
of the 1997 constitution
in 1997 sarta bukuba nyinto
set out in detail the procedure
ay kolu be itandile ke landi melu mutarambulo luti
for the removal of superior court judges.
Ni be kitindirla nyaton ko lu bondila kitibunda santon koto.
A judge may only be removed
Wo jojo wo wole mo kitindirla isa bondino nyamemma
from office
a bondi office kono
for inability to perform his or her functions,
ni amala du kulu keno anyama menketa sartol te nyanta mu tamandila
whether arising from infirmity of body
fo asekenyinti ko sasale ya sabo amari mantara afango sawola
or mind
wala asondomo mantara anoto
or misconduct.
wala ay kutinyari ngoke.
These are the three reasons that a superior court judge could be removed.
Nyinile mudalile sabolti me yalon ko na kitindir bunda santon ko isi kitindiro bondino dalilo menka.
A notice is given to the Speaker of the National Assembly
Aduni ye kalamutandiro di deputy bumbala speaker la
signed by not less than 1/3 of the voting members of the National Assembly.
ando asike kuti kaititi me yalon ko ni deputy olu be kafu nyoma yetala sidula sabati satara wo sidula fulo be kafu nyoma ya sign
Put forward a motion
satara wul fanali sarto ye kangolondi
that the ability of the judge to exercise his or her functions
kaitandi ko nyinkitindira pour kala do ko tamandino anyama
should be investigated.
inyanta ko kisikisilale.
If the motion is adopted
Ni nata wo kangolondi
following a majority of not less than 2/3,
aduni inata kangosoto me ya lonko ni dibitol tala wo sidula saboto sidula fulo nyimbe satara wuluye kangodi wo kango kang
the National Assembly also not experience that it has been used.
Well, I can suggest that in the Fourth Republic, you may have studied legal and constitutional history of the Gambia. Honorable Jabang, have you ever heard of this provision ever being used to remove a judge, or the removal of a judge for any reason at all during the First Republic?
Honorable Jabang ni karo mu itelati fo itela ila lonno re men soto ila karandiro karango ye men soto luala karola me marali folo ni jamano lanu fo ina naka jela ni kiditendi la ka bondi ni nyasi yo nyama ba.
Not to my knowledge.
Mambo kalama.
We can safely say at least it has never been used in Gambia's legal history before and during the time of Yaya Jammeh.
Nzinyi mfono le ko woto sona yako no ko nana mi muna fa wasilo ta mandiri nyala pour ka kiti nder la bondi woni silo la Yaya Jammeh la wato la.
But your paper, Justice Jaiteh, is premised on the fact that these removals were frequent. What was Jammeh using to do that?
Justice Jaiteh la in kaito re men karanteng ay tandi je ko Yaya Jammeh ka jojo kiti tendir la ke bondi silo men non nyalti me yalon ko dalina kulenu silang itela mira lodo no akamu tamande atakamu sembe sifa wala ka sila jumale tanu pour que muna fangala kanyin kiti ndir la santon kolta ke bondi la palaso.
In my view,
Ndela jeroto.
The removal of judges,
Urukao kitindirlalu bondi la palasoto.
Yaya
Jammeh
was unconstitutional,
ani banko la sarta buko mantanyola.
illegal,
Amanke loi silati.
null and void,
Andun ku kensa wala fanamu.
and of no effect.
Andunga man dalila soto.
And that is because
Andu wala minti katu.
the section of the Constitution that he invokes
Ateka constitutional la bunda men kaninga kaman kumandi.
is not a free-standing provision of the Constitution.
Amanka bunda lorin to membe lorin afaye meye baruma soto constitution okono.
Section 141,
Bunda keme talnani nin kilinjango.
subsection 2,
Ala fanna fulanjango.
either paragraph C.
Ala sappa sabanjango.
The President
Resdango nyin.
may terminate the service of a judge. Let me read it.
President asi jojo la du ku londino kamari dahandi.
But what I want to say here
Left a mem fola jang.
is either the President did not understand the provision of of the Constitution,
Wala mnyinti ko follow aseke ko president among constitution la bunda ma longa ma fahamu.
so let me read it to the public that the President may have his or her appointment terminated by the President in consultation with the Judicial Service Commission.
Wala mnyinti president asi wo mari la du ko tano ka mari bondi du ko la ning ayatara aning alfa kafo yomo yi men ya lon ko lebe du ko la kito ning kitindir sarto lu kurna banko kan ika fole Judicial Service Commission.
I think there is a nuance in the provision which is not reflected in the interpretation. Could you kindly, my lord, read the provision again, as it is in the Constitution, and then we have the interpretation?
So let me start. Section 141,
Bunda keme anin tanani nin kilinjango.
subsection 2
Ala fanna fulanjango.
reads,
Ayine fo.
subject to the provisions of this section,
Wol membe dending was dinkirala o sartola.
a judge of a superior court,
Kitindirla membe kiti bunda santon koto.
in paragraph C,
Wala sapa sabanjango to.
may have his or her appointment terminated
Sala do ko nying tano ka dahandi do ko la ning.
by the President
President sio keno ning ayatara.
in consultation with the Judicial Service Commission.
Nani alfa kafo nyomu menbe kito ni kitindir sarto kuna banko kan ika fole Judicial Service Commission.
So in my view,
Utontela jeroto.
it is either the President did not understand this provision,
Wala mnyindiko president mo dinkira nyanga malonga mafahamu.
or the Attorney Generals who were his legal advisors
Wala Attorney General meni alonko wale kate ya marnu lual ni sarto la karola.
did not understand,
Ulu mafahamu.
advised him wrongly,
Wala ya maro dia la meni sino manta.
or he was just violating the Constitution deliberately.
Wala be constitutional la kangole tinya kang adiyanyo o kang.
And the reason for this
Adun dalilo membe okoma.
is that section 141 subsection 2
Wala mbunda keme bunda tanani nin kilinjango la fanna fulanjango.
is subjected to the provisions of section 141.
Ufanambe dendi wosar tole bala menketa bunda keme bunda tanani nin kilinjango ti.
So subsection 2 is subservient
ala bunda fulanja woto fanambe dendin kulela
under the control
men yalon ka be men na maralo koto
direction of section 141.
men keta wo bunda keme bunda tanani min kilinja wala chodi bundati.
Subsection 2 cannot be used without applying the other provisions in subsection 1 in section 141.
Ite o bunda tamandino la afaye nin ayatara amantara dendin sartolu la men yalonko wolle be o bunda keme bunda tanani nin kilinja wonin kono.
So the application of subsection 2
itungo bunda fulanja wala fanna fulanja ko tamandi
is condition or contingent
wo mukuleti men yalonko abelori nyame ma
on the application of subsection 5 of section 141.
woto abet denna bunda lulun jangole la fanna lulun jang men yalon hanimbi wo fanambe bunda keme bunda tanani nin kilin jaw nyine koto.
Subsection 5
wo bunda lulun jang wo fanna lulun jaw nyin
laid down the procedure for removal of a judge.
wala ye sartolu landi purjin kamala ni lafta jojo bondila la do kola kitindirla.
What this means is that
we men firing wala munyintiko
that section must be applied first
wo fanna follow ibele follow tamandila
before the president can invoke
jannim president be kangotala
subsection 2 paragraph C.
uru fanna fulanjango la sappa sabanjango nyin kamma.
But what we heard
barintel ngamen soto nun
is that the president will just invoke the section
bari president ka wulile drong ay fanna nyin kumandi
without invoking paragraph 5 subsection 5 of subsection 1 of the constitution.
ate ka wulile drong ka kangota mandi satara amma wo fanna lulu njango la sarto fo membe dendin bunda keme bunda tanani min kilin jango nyin na lo nyala.
So for that reason
o dalilo ya sabu
there was the terminations
bayrolu ketanum
we are wrongful.
men ya lon ko ini silo manta fereng.
You would agree, my lord, that the provisions as written could be interpreted to include different means of terminating the appointment of a judge. One is retirement. Another is through resignation. One is through impeachment in parliament. And yet another could be termination by the president. I know you do not agree with that interpretation. But this is another way of interpreting it.
Yes, that is correct.
And the way this provision is written, it says a judge may have his appointment terminated by the president in consultation with the Judicial Service Commission.
Jojo isa baino ala dukola president si okeno ning ayatara ning Judicial Service Commission wolem alpha katom kakafo men belorin kiti bunda ni ta mandri nyaro ning adra ni wole nyomoy.
That provision too is also ambiguous.
O fanandi mu dingira de me yalongo nyosa bodo soro dajele.
One interpretation is that
follow kan men firinta je wala mintiko
the instigation for the termination should derive from the judge. A judge may have his or her appointment terminated. So one interpretation is that what would instigate that should come from the judge.
Do you agree
with that?
Yeah. I agree to that. That's correct.
Another interpretation is that since it is the president that terminates, the president can initiate it. And that is the way it was being interpreted by the Jammeh government. So what you have is two provisions. A provision that could be interpreted as resignation, because if the judge would instigate his removal, it would have to be through by way of resignation. And then you have another interpretation, which is the president can actually terminate. So you have two means of terminating the judge, that is by parliament and by the president. And this even leads to serious confusion in the constitution as to what is the right way of doing it. Perhaps maybe Honorable Jabang can help us here. In the 1970 constitution, what we had was resignation, retirement, and impeachment by parliament. You would agree with that?
Yes, exactly. And point of observation, I agree with the interpretation that has been advanced by my Lord the Honorable Justice of the High Court.
Nsonta satarola meya lonko honorable justice member kitibunda banyin ayewo me yitandi.
And assuming without conceding,
andunka quota satara ima ajube anyama,
that this provision of the constitution can be invoked by the president to remove a judge of a superior court.
Afoko president si tukuno wo sartola purka mo bondi meya lonko lem kitindirlati membe kitibunda bato.
I believe the provision is not an unbridled one. It has to be done in consultation with the Judicial Service Commission. So the president cannot just wake up idly and just terminate the service of a judge of a superior court. Just like that. Even though under the general construction of powers under the Constitution, if you've been given the power to consult, and you've done so, and that you are not bound by the advice of the authority that you are consulting, the issue of consulting is not excused. You must consult. So if we look at the way and manner the present Chief Justice of the Gambia was terminated when he was at the Supreme Court, exactly.
Supreme Court Chief Justice he
received a letter from the Ministry of Justice terminating his service,
purporting to terminate
his service. This was on all fours unconstitutional.
But can we say, as a middle ground, that this provision that a judge may have his or her appointment terminated by the president is a novel legal creation in the 1997 Constitution.
Tamandri silal de me yalon ko asoroto na 1997 Constitution bugola kono.
Exactly, and rightly so.
I think
with the aim of putting the judiciary at the mercy of the executive.
And this, it appears, evinces a legislative intention to tip the balance in the separation of powers in favor of the executive. By creating a new means of removal of judges with the sole caveat of consultation. And like you have rightly pointed out, consultation does not mean you have to accept the advice of the person or institution consulted. And whether it is constitutional or unconstitutional, depending on how the Constitution is interpreted. And we all agree that this is not normal in a society, in a democratic society, where separation of powers is anchored in the Constitution. Justice Jaiteh, do you agree that it's not normal to have such a provision?
Justice Jaiteh,
in a democratic society where separation of powers is given prominence as in this Constitution.
That is correct. And in fact, the provisions undermines the independence of the judiciary. And security of tenure. I believe as a whole, statute must be read as a whole. As I said, there are three reasons: misconduct, infirmity of the body or the mind. Amari kuja oleke kukurungu wala amari hakilo wala sondomota noto wala sasa dunta ajato la meya alamfundi.
Unfortunately, this particular provision is not grounded on any reason.
Bare onya nyara nyama nyimbunda nying among mama itandike hani silala jang mealon ko yewol la foteng.
And that is the scary nature of the beast that is created.
Wole nyara na masdango dundi ako nyinta ako nyinto.
It just says a judge may have his or her appointment terminated by the president in consultation with the judicial service. So if this is read out independently from the other provisions which you say should bridle this particular provision, yes, then this is a very scary creation. Honorable Jabang, what do you think about it?
Exactly. That is rightly so. But I think care must be taken currently interpret it independently, as you've mentioned.
Puruka akanna sore afaye afan kolongo ko ya foto nyami.
As my Lord rightly stated,
Ko na alfa ya funu nyami.
the law must be read together as a whole
Luwanyin ka karan ka ke bunda lorin kilmuti wala nyanda.
in order to make a complete sense out of it.
Puruka hakili nyuma mem kusene muti puruka wasoto je.
So that our democracy will be protected.
Puruka kamala na demokrasi sikanta.
So if you start reading the provision,
Bari niyo sarto karango damuta.
it says subject to the provisions of this section.
Kafuka ubetarla dending bunda karila sarto la.
A judge of a superior court may have his or her appointment terminated by the president.
Kitindirla me yalon ka be kiti bunda santon ko to mari president sala do ko kuntuno le ka dandi.
So the question that begs for an answer is, what are the formalities provided under section 141 under which a judge can have his or her appointment terminated?
Oto munne mu tarambulo luti mun be bunda keme bunda tanani ni klinja o nyin koto so president si yindo kula bayno ala do ko to nyamemma.
Your worship, you have raised a very important point.
Ye fanna kuma bale sikandi jang.
And it is akin to the point raised by Honorable Justice Jaiteh.
No bebe sujiri ni Honorable Justice Jaiteh afana fanna me se wurindi janteng.
That you cannot read paragraph C as a standalone provision.
Yes.
O ite sabanyaw ni ta karandino la kafuko mfanna de me alon ko abeloring afayen.
But you see, paragraph C creates its own mechanism.
Riyaje o sabanyaw ni fansum tamandrisilo ay wala londe afaye.
So a literal interpretation
Woto ni bo frina
would suggest that you don't look for another procedure because the procedure is already inbuilt in paragraph C.
Abe tandile je ko ta manjara pour yeta fan ye bulfula nyaw bi be katum bulfula sabanyaw ni ati afan sene andile.
But all this discussion
Bar nyin ka chalu be kono
goes to show that there was a deliberate intention
ni tandije ko wete tawnte ya bara balle be kerin
to give more powers to the president in this constitution,
kasembota ka beta ka jama bata ka di president wala nyambe ya bondi nyin constitution bu ko le kono
which you would not find in a normal democracy.
andu mu tamandiri silol de me yalon ko democracy be tamakan dawoda e buka bara tamandiri silol sifa bulu sifa le buko jeworo.
And may I just take the liberty to inform that I did my LLM thesis on the draft constitution.
Mbadonga nyin kalam dal kalam dañin ko mfana nganna LNMTC ngakele pour safero.
As at the time I was writing
Wato men be safero kela
my first draft of the thesis, this provision was not in the constitution.
Safero folo nyi wato men thesis kela nyi luwala bunda nyi be men fokante ate buko nyi konon.
So this was a late addition to the constitution
Muka fundande de me alon kanara na ke ko nyaado do mandinne
aimed at empowering the president
hamo memba ko ma wala nyindi ka president nyinta ka sembenti yandi bake fa
to the disadvantage of the judiciary.
isaje nyin kamala ko kiti bundar nyinna ila de tokan.
But I read this
nganyin karang
as the beginning of the creation of a dictatorship.
Kaje ko be sembela maralo nyinda mutadula folo nyin wato lem.
Because the people would rely, the people's last hope is the judiciary, and the judiciary was rendered impotent in the presence of the executive. And what do you think, your worship?
Molla jigida laba dingira men to wolem kiti bunda and kiti bunda fan killing wol fanan wol fanan kita molle me yalonko ibe molle ko me yalonko ka fo executive yo wasibite mun sala mem folawor.
I will have to align with your statement in total.
Ila kuma kan fungan na ko tembendi wala fe ko ya fa nyami.
So Justice Jaiteh, the judiciary had a preferred interpretation. That is the one you gave.
Judiciary memu kiti bunda di toli la kanna sor la nyasilo la soro me alon ko itoli kiti bunda nyinya na tamara o silo landu ite wala karante.
It is quite clear that Jammeh did not support that interpretation.
Anunga seneya tala ko Jammeh ataw kanna sor nya bunda nyi luwa ite ya kanna sor nya me ya Jammeh amo fasa.
Tell us how Yaya Jammeh applied this provision.
Silang afonye bangate Yaya Jammeh ate munafanya mbunda la luala mbunda do la mbunda la nyadi le.
Thank you, Council.
Numbara Council.
Well, yeah, you know, I do not even believe that the Yaya Jammeh would just dismiss or terminate the service of a judge.
Man la nyim fawno ko ya jamme be wulla dron jojo wala kitindirla ka wala duko londi wonya ka bay la duko to wonya
in the consultation
satara nyojo la karola o manke ko soto
that is on the paragraph C.
min ya lon ko be sappa sabanja wonin ko to
In my view has never been applied.
na jero to ene man tama o silola
Because as a judicial officer,
katu membe du ko la kitoni kitindir mundala
if an allegation is made against you,
ni tumiro la itemari kan
it cannot just be oral or verbal.
ate kelo la kumakala kense woti wala kalima kense woti wonya dala foro
It must be written.
anyanta kila fen safari ngoleti
And the judge must be given the opportunity to react.
andu nyanta silo dilawo kitindirla fonla prate fanaye kujabi woto
If the Judicial Service Commission will do that, to react to that allegation.
adu kitindir bundala alfalu mulbe kiti kunyalu kunna Judicial Service Commission
Judicial Service
fanali nyanta
Commission.
kuta mandile jele
And the Judicial Service Commission will make a decision as to whether that decision is substantiated, that allegation is substantiated or not.
to alfa kafo wolle bina kangolondi la kafo ko yetumiro mem fo nyimma fo kusoto lem bam fa manke kusoto
Because the president is not at the judiciary.
adu president mandara kitindir bundala
It is the Chief Justice.
Chief Justice lem
And he is the chair of the Judicial Service Commission.
andat la fana musiranti to alfa kafo men be kitindir kun kunna
The Judicial Service Commission is responsible for the judges and all their welfare.
wo alfa kafo Judicial Service Commission wolle fanal mata kitindir la ni kiti telal la
For
kunyala
that reason why Section 141
dalilo le ya
is a
sa
consultation.
fo bunda keme bunda tannan nin kilin jago be laari nyojo dalilo le kan
Is it your view, my lord,
My lord fonye mitala jero de ba.
that you believe that the consultation or the consultative process must involve due process rules, the observance of natural justice rules? Is that your position? That has to be part of the consultative process. That there has to be audi alterem partem, that there should be notice, and that the person should be given reasonable opportunity to react to the allegations. Your belief is that the consultative process must necessarily include those natural justice rules. Is that your position?
That is my position.
wala mun na lodulati
That is an interesting interpretation. I am happy that such creativity is coming from our judges.
wo mun yoje nyabori mbalete alum akatanyen denye kuti kafoko wo botan na kitindirlal fongol bulu
But you would agree that the literal interpretation of that provision does not require natural justice being observed and due process. All it requires is basic consultation. That is the literal interpretation.
Betata nata wala mindiko anyana firina ni nyala yalon ko nyomo nyana tarrasulullah ida malte male
membe la nyo fahamo kan
Yes. Council, you are absolutely right.
dan sulimu to nyale moti
See, the removal of judges
ka kitindirlal bondi la palaso to
in any democratic society
demokrasi banku kan
should not be willy-nilly.
amanya na kala ku ka keke la tendron danko dron
It should not just be so easy,
amanya na kala kuti mensi sono ya ka keke la wonya
because judicial officers
tatu menu bo kitio budu ku bundala
are the last hope
wala molu jikila bangote
of the citizens.
molem banko molu la jiko tukul la bangote
When the citizen has a problem with the state,
nim banku dumo kole ya kosoto anim banko
they run to the judiciary.
ikaburi kata kiti bundale la
When citizens, two citizens have a problem,
nim banku dum fula kole ya soto nyotema
come to the judiciary.
kata kiti bundala
So that institution
woto wo bunda wo kiti ndir bunda
must be, the judicial officers cannot just be removed easily like how we have it in the constitution.
woto kawulu bondi la palaso ta manyan sono yala wonya ka ga soto na constitution ko nyami
how it was done.
we ba ke ka kanu nyami.
In a sense, you are saying that this provision we have in the Constitution weakened our democracy and strengthened a dictatorship.
That is correct.
And tell us how it was applied in real life and the impact it had on the judiciary.
Silang afonya ike muna fangala nyadi lenu wato andu ngai mun kulea kulel sabu na kitindir bundal.
I asked this question noting the point you raised in your paper, saying when you said in paragraph 4 that by subjecting it to the removal of a democratically elected National Assembly and establishing a higher threshold of action by that body, it remains vulnerable to politicization. And then you went on to say that in practice, this concern becomes more apparent in view of the strong majority of the ruling party. You were there talking about the other provisions, their impact.
Yes.
But perhaps before then, tell us the impact of paragraph C, 141 paragraphs, 141(2)C, and then we would come back to the general import of 141 in general. Tell us about the net effect of 141(2)C as interpreted by Jame and the executive, pretty much.
Well, you know, the impact of Section 141(2)C.
Section 141 wala bunda keme bunda talnan ninkilin jawla sapa fulan jawla bunda saban jaw nyim
Is that there was no due process,
ñina itandi ko tumo kulorin te kerin num
and judges were arbitrarily terminated
ne ka ketendir la lu tale doron ke bondi le la place solto
without giving any reason
adum dalila bukadi
as to why they are terminated.
munal na ye bondi do ko wala.
And it also gives the executive the power
and akanyi sembo fanandi utumo banku nyaton kola
control
urka kamota mandi
over the executive,
kitindir bunda
over the judiciary, sorry, over the judiciary.
kitindir bunda nyin kunna.
And also it creates fear.
And aka silanya fanan natile
There was no security of tenure.
kado tumo kanton in tankate palasi kunna.
And it also distract
and
competent people
akan no lalu ni lonnalu fanalu hakilo boyla do ko kanne
to be attracted to the bench.
mprin kamala yenasi o kitindir do ku bundala.
So at the end, judges or individuals or lawyers who are competent enough
ko woto ko nata laban men na wala minti kitindir lalu men ketal lonnal ni no lalu ti ado ko nyin na karola
fit and proper persons
men ya lon ko keta makamatioluti ya keta amoluti men sake
are not attracted to the bench
ibukala fi purkana wo kitindir bundala ka fadam ya bench
because they could easily be terminated
tatu ni nata je fana isi bayno le ku ndin kono dron
for no reason,
adu dalilate tarlala
and that could be humiliating,
andu fonga sikeyo maria maloti
embarrassing,
sikeyo doya roti
and demoralizing us.
andu asimari la miraro fon fanan jindi.
So it was literally, this provision literally was to kill the judiciary.
Amunta wala mnyindi ko tel kata manu menna wala mnyindi purka judiciary wala mka kitindir bunda nyim fango fa
Render it as a tool of oppression.
ake joranti me ya lonko mole be muna fanna la ka jora yandi.
You will end up having judges and magistrates
Allah bango katake nyindi jojol ni magistrate wala mkitindir la ni kititela
who will be compromised
men ya lonko la palaso nyi amunta ite ludula sotola
and compliant.
andu bitu baje la ko songote keno la ko la.
Perhaps let's not go back to the other provisions of 141, even though they have problems. as you suggested, it's a normal provision you would have in a democracy. And it is miles better than the dictatorial provision you would have under 141(2)(c. Tell us one classic example where 141(2)(c was used for the benefit of the executive. I am looking specifically on your mention discussion on paragraph 5 of your paper.
Well, the section, as I said, section 141, 1 to 4.
Kuma fulu nyame bunda keme bunda tanani kilinjango kabwa fulu la katana ninjawti
4 to 9.
Abo ala bunda nani njango katala bunda kolonto njango kang.
It's a procedure
umukulanya letime yalong
that there's a procedure of removing a judge
wole mkulanya ti purka jojo bondi ala palasoto
and subjecting it to parliamentary scrutiny.
Ando fanambe tarla dalila le kamme yalon ka bekel député bula korosiro le kandi.
That provision has never been applied.
Inene mantama o sinola.
But there is a danger in that provision as well.
Bari kolea kobe o sarto fanan konole.
The National Assemblies of the previous administration
député bum fololu menu bijam marali fololu la wuce kono
were rubber stamped or were subservient.
Wala munta doron danko doron député wala moyete bari bitum katara a konyim fango dalilo kan
To the whims and caprices of the executive.
munta wol katara banko kundon kola kangoni ala kolu lanya le koto.
So subjecting the approval by an elected National Assembly
Ka kolu la bundala me yalon ko le kata député buti quartier fayta menni
either could be politicized.
isa keno politiko siloti
There could be a majority in the National Assembly,
anda sikeno itelle siata bake député bun kono
and because of a judicial decision
barka foko wari député kiti bunda kangoleta
could be easily removed. The judge could be removed.
sia kitindir la nyum bondino wala palaso to tarinke fa
So the whole process
Between
before the National Assembly
ko nyum fango be lanya député bun nyati wala
politicizing the removal of judges.
pourka jojolu la place ta ke bondi la place to pourka ke politiko siloti
However,
baro nyonyandi
the procedure has never been used
asilo nyin inene me muna fangala
because it's cumbersome
kato akonyi ku jamale bakono
and the executive or the president, was just using it, just giving orders to have the judge removed.
abunta president ne wotumo wala kundon ko nyate ka kangoli didorong pour yo jojo wala o kitindir la ya bondi la place to
Invoking section 141 subsection 2 paragraph C.
amonta tela kanindro katar larin bunda keme bunda tanna nin kilinja wala sapa fulanja ala sapa fulanja ala kan aningala bunda nanin jam.
Yes. So judges, example of judges being removed, there are a lot of judges whose service were terminated.
amonta snyaji be mansalum kamara ye joju jamal le la palaso lu bondi bu sila janke fonyondi
The Supreme Court panel
Supreme Court wala mkiti bunda balaw alfa silinu
involving the Chief Justice himself,
tabula Chief Justice Fangola,
Justice Chauhan,
Justice Chauhan,
Justice Jibujane, Honorable Justice Jibujane,
Honorable Justice Jibujane,
Justice Sok,
Justice Sok,
and other judges who sat
Amin George Kotolu, menu sita kuna.
were literally, arbitrarily removed.
Yolu be bondi la palaso to wala nyama kutare ukang.
And there was no reason
Arun dalila tije.
why their service was terminated.
Ka fo nyina ya sabu ya la palaso lu taybulu.
And the Supreme Court became, there was the Supreme Court became vacant.
Arun wala na Supreme Court kiti bunda ba nyina ta kolonya.
What must have precipitated that?
Because they gave a decision.
Tafi ya kangole londi.
In which case?
In the case of the Lantomba.
Men kata lantombo tamba la kito nyin konoti.
when they reviewed it and decided, to reduce the sentences.
biri ya jube na tanyin kamota purka ya soro yirko men na purka utala
Acquit and discharge Sadio Fofana.
ina ta Sadio Fofana la kito buruka ki abula ya tata.
In my view, the president thought that was dangerous.
Ndela jero president ya merako umuma siba kole tunu.
So in effect, the president, Yaya Jammeh, did not like the decision of the Supreme Court reducing Langtombong Tamba's sentence and acquitting Sadio Fofana.
Munta President Yaya Jammeh amalla fi Supreme Court be mun kiti bunda sandon koti wole kama menta pour ka Langtombong Tamba sorondiro me ya kala pour ka law sanjo nyinka tala anin Sadio Fofana ko ta ka bula ka je ko luwa mamuta no kiti yo fana ya bulale amalla fi wala no.
But he didn't give this as a reason.
Rata mawdi ka fo wala mdalilo tide.
But he reacted to this decision by the Supreme Court.
Bara simfanyi taw ko kangol la mealon ko kiti bunda sandon ko nyinga yo kango menta ay simpata wal.
Yeah, that is correct, and fired the whole panel.
Umto jalta na ta panelo muno nyimbe handi.
And there was no Supreme Court.
No to tembo Supreme Court bunda man soto.
As on the basis of the information you received,
Ite kibaro men soto.
was there any consultation as required by the provision that he relied on?
Po nyomo yo soton taliban ko ite bunda me yalon ko ite ko ajujita no bunda nyinna la loi bu ko nyin kono.
As far as you know.
Ite la lon lodo.
There was no consultation as far as I know, and the information I received from other judges as well. There was no consultation.
Konde nga kibaro men soto joju dol bula nin kitindiri la dol bulu. Woto nyoje nyomoy manke akoni mumo kono fereng.
It therefore means,
even
if one were to accept that Section 142C can be a stand-alone provision,
Section 148
142C, he violated the requirements of that section.
That is correct.
So it means that even if he could rely on 142C, his action was unconstitutional.
That is correct.
Was his decision effective?
In view
of the blatant unconstitutionality of his action.
Well, the former President Yaya Jammeh was the alpha and the omega.
Break that down for us to understand.
He was everything almost. What he said, is decreed.
You, that is just sort of saying he was the dictator.
Well, because if you look at it, is the panel of this is the Supreme Court, the apex court, and the Chief Justice himself.
What it
means in plain terms is that the president arrogated to himself the power to remove entirely the top echelon of an equal branch of government.
Amunda president wa sila leta meya lonko ay sembota dia fanga ka bunda janja meya lonko bunda la meya lonko to lem nyaton kolti surdu ka nya jube luala karola sembol be talari nyoyete ma nyamen ka bunda nyaton kolta ke bonde ate wolake.
I'm not sure that is the exact interpretation.
Amunda president wa yin dunota fankan mansa kunda bunda membe loringa faye ka wola o nyaton kolu mundo lu be bondi law palaso.
And this is an equal branch of government. That is the crux of the matter. And the equal branch of government, a branch of government that is equal to the executive.
And bundal de me yalon ko ma fa sum bundal de masakunda do ko la karola andu ata fanam bundal de me yalon ko atele masakunda ni dabe masakunda bundal ko no me yalon ko be lori faye.
That is correct, and that was the beginning of a very bad start of his own downfall.
Omutonyalde adu wotumo ate kulu datonya mu datirinya jawbalete adu wala fona take daliloti me yate fangula kulu tinya ka boindi.
Because in my view,
atuntela jeroto
the Supreme Court is a very important court.
Kitibunda nye Supreme Court mu kitibunda kuma baleti.
It's the constitutional court.
Wole mbankola sarta kitibunda lori ngoti.
And we were approaching a national election, presidential election.
Andu wotumo ngantilim president karte fayole la banko kan.
For that reason alone,
Wodalilo damang
there was a need to have a full panel of the Supreme Court in place.
Waya sabule ko Supreme Court la bunda saharim bunda timmari wanyanta la lori ne wotumo.
Because there will be need, for petitions to be filed to the Supreme Court.
Adu solo betar la nyinale safer la be soto la menube ila kalamirolu safer la ki Supreme Court
to challenge the decisions.
Puru ka kankalo kangolu dolu nyato puru kangolu dolu ke soso.
The firing of the apex court, this constitutional court, in 2015.
2015 puru ka kiti bunda alifalu mumolu ke be bondi o palasoto ki amuta do ko bunda mumelu la kunton kolu ka lu be bondi
few months before the National Assembly, before the presidential elections.
The fula janin karte fayobe sila
was crazy. And no saying the president will do that.
Omu kuleti me yala ning hakilin tayale formulata omu kuleti me yalon ko ku kebalole moti momanya
without having a replacement also.
And we manna dolu kinye men si say wo dol la palasoto.
Perhaps maybe he was
if the election decision was the reverse, it may have been a genius decision by him.
Ninga tra ukarde fo nyingala results o nyingana na findi ni nyado nyamon abe kala non kudol te me yalon ko abe bola la karol.
But poetic justice, he was hoisted by his own petard.
Absolutely
correct. So that is the danger. That is what he thought. He thought, it would be the other way around, but he ends to. That was the beginning of his fall.
Atela miroto, atela mirawole mkukendo tiatefe. Baribitu wale na atake atefongla boyoda mutablati.
Justice Jaiteh, proceed with with the rest of your present.
Justice Jaiteh,
yes,
point of observation. I just want to bring to your attention that in a serious democracy,
lefta e hakilo bulandila nyumfana ko democracy sobo bedaoda,
it would have been caught under section 67 of the Constitution.
Anyanta tarla bunda taworo ni worowla njang koto na bankola constitution okono,
which could lead to his impeachment.
Me yalon kasike sababu te puri atefango ye akito sa ulinde atefango kama.
Whose impeachment?
The president.
Puru president ufango la bayro.
For willful violation of the provisions of the Constitution.
Puru njin kamala aytaunte ya leke ka constitution wala kamulu buruka ka balang itamandila.
I underline in a serious democracy.
Exactly.
Democracy sobe obedamento.
Thank you very much for that observation. But you see, Section 67 has never been invoked in this country.
In
fact, when matters came to a head, what was done was to extend the life of Parliament, which automatically extended the life of Jammeh's presidency in the face of a resounding and clear declaration of the sovereign will of the Gambian people that Jammeh's rule must end now. His rule was extended by extending the life of Parliament, tantamounting to almost treason, because it's an overturning of the sovereign will of the Gambian people.
bari mun nata ke wo dalili go kolu kono amunta Gambia banko dingolu yennaniyo me yitandi ila fitam menna yole fintindi carte keso la karola bari mun nata ke inata itelamara lo wucce wala fa ya tela nyaton kaya wucce wala fa me ya lon ko bemu kuleti meluni banko jam fa jawole tata nyola tubabul kafo me trisin o mu kuleti me ya lon ko itel data lo wala kam me ya lon ko amuku ke balota buka ka manyan kala fanan.
But that is a conversation for another day. I'll allow Justice Jaiteh to proceed with his presentation.
Thank you, Counsel. So while the removal process set out in section 141, paragraph section 4 to 9,
bunda keme bunda tanani kilinjango ala sabanjango la bunda nani njango
of the 1997 Constitution,
member 1997 Constitution okono
offers some safeguards for judicial independence.
woye lula dolu chodi le puri kitindir bunda la taram fambulo anyanta lola nyame
By subjecting it to the approval of a democratically elected National Assembly,
andu muyenyine itandi ko député bumme ya lonko karteo fayta député lu men ye tilimu ni Sénégal kono satara wolle fonglu fanal bina kamodi la pour ka bunda londi
establishing a high threshold of action by that body.
andu wolle nyanta kuketa saharingulu londi la me ya lonko député wolle be o kamodi la.
However, it remains politicization.
bala yo nyanding atutalarim politiko nya la nyale la karola
Vulnerable to politicization.
me ya lonko politiko kansi duma kono nole wate wate
In practice,
ba Kenya to bang
this concern becomes more apparent in view of the strong majority of the ruling party in the National Assembly,
mi nata ke kanti me ya lonka findita mo jama me ya lonko wolle be patio kono melu be mararola nim banko kanu
and there is therefore a risk of politically motivated step
andu goto nyimukuleti me ya lonka sike kole akuti me ya lonko politiko simfatari mole moti
remove a judge.
uruka kitindirla bay ala palaso
Is successful.
wo bunda lori wala karo bunda lori la karola baro nyon
The presidential power of removal under section 141(2) should be
bari president wala sembo wo bunda keme bunda tanani kilinja o kafu ka kitindirla lu bondi
subsection 2 paragraph C
mem ala bunda fulanja wala sapa sabanja ko nyinti
is of serious concern to judicial independence.
ku kole mbaleti mdewum ku balemu kitindir bunda la taram fambulo la kolu kono
Even the institutional weaknesses
a même ce que do ku bunda fon la sembe do yati
and the dominance of presidential appointees on the Judicial Service Commission
andu asina ke ko presa wala mu tombo ndingulu wolle bina siala itelle be sembo sotola wo alfa ka fo kono membe talla kitindir kunyalu kunna ika ko bunda me Judicial Service Commission.
the absence of any constitutionally based safeguards
andu wayata constitutional la tukun saharngulu dodo teje
requiring a fair and independent process
me ya nyin kanin kosike nyama men senata lankene mata tilinda
the apparent discretion of the president
to menata sinake president fon la miraro na la jeroti
remove a judge without consultation,
urka jojo bondi satara nyomoy nyonyinka nyo kacanditi kala
the
ko
agreement of the Judicial Service Commission,
me ya lon ko fanan ate kala kambenti me ya lon ka botawo alfa ka fole bulu Judicial Service Commission.
this power contains no protection for judicial independence.
o sembo man dalila wo dalilo soto man kantari wo kantari soto kitindir bunda la taram fambulo kono
This constitutional procedural weakness in removal of judicial officers
bitun constitution la sembe naso puruka wo kitindir bunda la alfalu bondi
was arbitrarily used by the former president Yaya Jammeh
wo mukuleti me ya lon ko president o katu muna fannale wala dron wati ya jamme katu tamandila dron
in the case of Lieutenant General Lantombon Tamba and the state,
sako ko men keta Lieutenant General Lantombon Tamba la koti wato men anim banko be kito la
Sadio Fofana and the state,
Sadio Fofana nim banko la kito
consolidated criminal appeal,
andu nata bunda lorin soto men keta kuruya ko kito sa inkangoti
where the Supreme Court delivered a unanimous decision
the men Supreme Court nata kam lorin o banke
and upheld part of the sentences of the convicts
inata ni mo mutarinula fanna dolu muta ye soron kamulu mennu kan inata fanna dolu londi
and acquitted and discharged one of the convicts,
inata mo kilimbula me ya lonko kolua ya bula le fereng
and set aside other convictions.
itu inata sorondir dolu londi dolu fangul kunna
Following the pronouncements of the judgment of the Supreme Court
Supreme Court nata bankero ke ila kangulu laiteliye men londi
in the case of Lantombon Tamba
men keta Lantombon Tamba la koti
and Sadio Fofana,
ani Sadio Fofana
the presiding justices of the Supreme Court
kitindir la lumon sirim mum kitin bunda ba na Supreme Court la karola
summarily and unconstitutionally removed
inata nyin tamandi kutarin kono andu inata ko tamandi nyama menning sartolu mantanyo la kamolu bondi
from office by an order of the former president Yaya Jammeh.
pour kamo bondi ala palaso to me alon ka keta Yaya Jammeh la kangole kang
No official reason was given
dalila mandi ka fo nyine ma daliloti
for the removal of the judges,
pour kamo jojolu bondi a man dalila soto
and no consultation took place.
andu nyojew manke nyomoyo manke inin alfa bunda tema menu marta kitindir bundala e ka fo bunda me Judicial Service Commission.
Constitutional provisions set out in sections 1414 to subsection 4 to subsection 8
bunda me yalon ka ketaw bunda ke me bunda tannan nin kilinja wala bunda sabanja nin ala yirkaro kabuji kata hanfu wala bunda sayinja mo jinto
were never followed.
inna mambula wolu hani kilin noma
Rather, the former president
bare am nu wotumo membe president nu wotumo
resorted to weak constitutional provision.
ate ye bankola constitutional sarto leta menketa nasi sarti nasi mo nyinti
Summary and unconstitutional removal of judges
ga jojolu tariato bondi mem fanani sarto lu manta nyola
and their reappointment or reinstatement
pour kana tombon kota ke wala ke murundina o palaso luto
created an atmosphere in which judges are unable to operate freely.
anata bunda londi budame ya lonko kitindirla lu bikela ko lu tamandino ifambulu ite fambulu
For fear of removal,
akato tumo katala silandi nyina la ko bembaylale
and that has posed a serious threat
andu wonata silandirinya sarin bundi
judicial independence for judges.
bankola kitindir bunda la taram fambulo ni la kallori ngo tamando kono
The former president's perception of this ability to remove judges at will
president lawo jero ka fokate sikitindir la lu bondino le nyawnyandi diata teye
and the lack of a need to comply with the constitution
andu mansoto pour ka son katama constitutional sartolla
was a cause of deep concern.
wonata ke dewum bati
Lack of security of tenure
kantonin tankaman soto moye ila palaso marola karola
and the fear of the former president's interference
andu silango be kerin o president la abulonin adabulo kitolu kono
was a major disincentives for members of the Gambian legal profession.
wonata ke kitindir bunda la do kula jamae kuti meya kendi hanfo ilafte kodi la do ku bunda nyina
Consider a career at the bench.
pour que mira pour kata do ko ke kitir bunda la ay silandi ala ay nyorindi ala
thereby seriously undermining the growth and development of the Gambian judiciary at the material time.
mennata ke sababoti Gambia banko la kitindir bunda ila kito tamandi bunda la yirwa ala tanyato ala sembo la lo ala taram fambulo ayo nasindi jawke hanfo dandula mansutwala
It was prevalent in the previous governments
lotanu follow mansa kunda follow lukono nyamin
where attorney generals will come over to the judiciary
demen attorney general lu fonglu kana kitindir bunda la
to lodge complaints on behalf of the executive to the Chief Justice,
pour kana banko president fongla kalamiro lu futandi Chief Justice ma
who would summon judges,
mensina jojo lu kumandi
magistrate to his chambers
ani magistrate lu ke kumandi ala office
to challenge them on their decisions.
ulu ka lo inyato ke ichaling ilawo kangulu kang yemenuta
Attorney generals in the past government
attorney general member tata bansa kunda tambirngulu kono
often told the Chief Justice what to do
modolu wala fawlu ka fo chief justice ya nyanta menkela
and indirectly control the judiciary.
andu wotumo wala fawlu kana judiciary kitindir bunda nyi mara satara itelu mantara lankena marin
The state resented,
itum bankona ta balanda sotoje
repressed any judge
andu ye deteroke jojwo kitindir lawo kitindir lala
who was independent
me ya lonka ba fayya ba fambulu
would be treated shabbily.
si ku noringo ke marila
Judges who were independent in their work.
Kitindirla lumen ya lonko ibe faye be fambulu be la do ko tamandi kan.
They are receiving death threats from the government agents.
Wolu man sakunda do kula lu fawlu ke silandi ka foye ibe fala.
For giving judgments against government wishes.
Ruka kito te nyama me ya lonko kito te nyama mandiya man sakunda ya man sakunda fasa.
Judges and magistrates
jojolu ni magistrate rolu
had to leave the bench because of several attempts on their lives due to their independent decisions.
Katu dolu fangu bije ye sinya jama soto ka lafifa laika kana katu ye kito lute dalilo lukan yamin aninka tonya tamandi wala mu dalilo lute ka lafifa la.
Judicial officers who rendered decisions not favorable to the executive.
Itindir bundalu anil do kulalu meni kawlu tamandi menu mandiya banku nyaton ko yewutumo.
We are not allocated official vehicles.
And
we are denied basic entitlements. Their case files were taken away from them. Without notice or justification. Judicial officers were arrested and detained for their judicial decisions. Made in court. And their service were terminated without recourse to the due process of the law. It was common for judicial officers to be hauled before a magistrate's court. On flimsy allegations. And the residence of judges were boggled. Valuables taken away without any investigation or arrest. Complaints made by judicial officers to the police on robbery and burglary fall on deaf ears as they would do nothing about it.
I think the chair wants to intervene at this point. Did you indicate? But in the event the chair doesn't, this is all as a result of the environment that was created by Jammeh's interference with the judiciary, resorting mainly to the tool that is granted to him under Section 142C.
Yes.
What is your legislative prescription for Gambia as to what we should do with Section 1.142C? 141.2C. Yes. What is your legislative prescription? What should we do with that section?
I think if the section, in my view, and the view of the judiciary, we had it before the draft constitution. Our paper to the Constitution Review Commission. We strongly recommend that portion must be deleted.
It must be repealed.
Yes, repealed.
What was the reaction of the CRC?
The CRC deleted it. It was not in the draft constitution.
CRC sila Constitutional Review Commission ulunata munetamandije sedo ko tonya ya bondije le manna dundi constitution kono.
But clearly the draft constitution has not yet passed. It would be a wise recommendation
recommending
to the TRRC that section at least be repealed.
Yes.
Munda lead council kamunyi ka wala minto woto wairi wo constitution kuto amallo follow pour ka tama wala woto hanimbi wo bunda nyin ni nyanta kala yamare tilindin tikka fo TRRC en pour wo bunda nyin hanimbi ya burka ya tobo ya bondi kono ya telandi karala.
On that note, Mr. Chair, I ask that we take our first break. Yes. And when we return, we would look at examples of interferences with judges and magistrates.
I think that's good timing. Extraordinary abuse of power. Anyway, we'll resume at 12:30. We take a 30-minute break. Meeting is adjourned. Thank you.